we're going to go through it and see how CLE does its questions, and also so that you can put your mind to what you've been studying and revising all along. And to start with, I think I can tell, I know by now you've been given so many advices on how to prepare for your exams. So I don't want to be repetitive, but I'll tell you that with civil litigation, it's really said to be very bulky, but as you will see as we discuss this paper, that you can actually prepare it very simply and be able to do your exam well. So just first things first, at least be aware of the various topics that you are taught in class. Know a little something about each topic, and I think you'll be good. And trust in yourself and pray. That's my advice, by the way. Trust in yourself, pray, and just uh, do this thing. Don't look at it as a giant, but look at it as something that is possible. And also, don't focus so much on the marks that you got in orals and group work, whether they were good or whether they were bad. Put them aside and just focus on this paper and aim to get the highest possible. It will help you. All right, so question 1. All right, Pius Onyango, could you kindly read for us the question?
Good evening, fellow students. Good evening, Makena. So the first question.
Good evening, Pius.
Yes, the first question. Tom Pillar, your client filed a suit against Sungura Limited, claiming a sum of 5 million. The case was heard and judgment was delivered in favor of your client. A decree was issued and it is still unsatisfied, and your client informs you that Sungura Limited has an account with Mkulima Bank Limited with 3 million Kenya shillings. The account number is 123456788. Your client is apprehensive that he may not recover the amount. Draft appropriate pleadings indicating the nature of reliefs you will be seeking. Thank you.
Okay, thank you. So this is question 1. So before I go to which pleadings to be drafted, can anyone tell me what the question is about, or rather what the problem in this question is, so that we can be able to identify actually what pleading we're drafting? So what do you think this question is testing us on? Yes, George.
Hello. Based on the question,
Yes.
This proceeding.
Judge, could you kindly give me a moment?
Yes.
I think I can't hear you properly. Let me get my earphones. Maybe it's on my end, but
McKenna, it's not on your end. It's on George's end. So please get the
okay.
Get the comfort. Thank you.
Okay, so George, I don't know, maybe you can try again, but you're not audible. Come again.
Okay. I'm right here.
Okay.
No, you're not.
Okay, just give me a moment. I get my headphones so that I can. I don't know if you guys can hear him, but I can't.
We can't hear him properly.
Okay, George. George, can you be heard? Can anyone else wants to attempt as George takes care of his audio? Okay, George. Okay, there's Donna. Let's have Donna then. George, you can come again.
Okay, for me, I think this question is testing on garnishee proceedings, whereby you have an order against someone and you know that someone else owes them money or has a property. So you apply to court to get that property that is owed to them or that the other person has. So garnishee.
Okay, so Donna says garnishee. George, do you have a similar view? Or
Yes, I'm of the similar view. It is a garnishee proceedings subject to order 23 of the civil procedure rules.
okay, great. All right, so Donna and George says that this question is testing about garnishee proceedings. That's great. Can anyone expound what is garnishee proceedings and under what topic is this garnishee proceedings usually come in civil litigation to help someone who maybe is not catching up with us? Yes, Jura.
Let me give it a try. But this question tests us on the execution of a decree where the decree holder is unable to execute for reasons that the person against whom the decree is issued has not satisfied it or has not complied accordingly. So in the circumstance, you target now the third party who is owing a person against whom the decree is issued to be compelled by court in a way to come and show cause why he cannot pay the amount that is owing to the other person, to the decree holder. So now that the question is asking about appropriate pleading, I don't understand why it chose the word pleading, but for me, I would approach it by way of an application as a decree holder against a decree. Is it the decree? Is the decree creditor, decree creditor, and decree debtor? I think those are the terms that I'll choose to use. And again, against a garnishee, which is now the bank that owes the money to the decree debtor. That would be my approach. So in the circumstance, the enabling provisions that I'll rely on as I make the application, I'll rely on, of course, Order 23. I'll also rely on Order 51. Thank you.
Thank you. Thank you so much. I'd like to highlight something that Jura has said. He has said this question is about how to execute a decree, and that's what I wanted all of us to be able to get. So before we, I think it will be best so that you can revise, widely. We have come to learn this is about executing a decree, and one of the ways of executing a decree is through garnishee proceedings. And I think Donna explained what garnishee proceedings are, and I believe we are revising. We are not like learning unless someone really has you don't understand the term garnishee or what is it. You can raise your hand and say, "Hey, I'm floating over here," but in simple terms. Garnishee proceedings usually comes about when you are executing a decree and you have tried these other methods of executing a decree and which were not successful. But now you want to get money from another person who's not the judgment debtor. Let me break it down. in a case, say there's a plaintiff and a defendant. A judgment is given in favor of the plaintiff. The plaintiff become a judgment creditor and the defendant a judgment debtor. The plaintiff should execute the decree against the judgment debtor. But now the plaintiff is saying, I've tried all means to get money from this person directly and I can't. Now I know there's another person who has money belonging to the defendant and I want to access that money. Then that is where Ganishi comes through. Are we together? Some thumbs up. If anyone is floating, you can raise your hand. Justice, is your hand up?
That must be a no gun.
Oh, okay, no problem. All right, so that is the first thing. When you are looking at a question, you need to identify what is it being tested here. So you have identified this is about execution. So you look at it and you look, what kind of execution is this question testing? Sometimes you might be even asked to execute. So just briefly, before we go to which appropriate pleading, before I ask you which the appropriate pleading is here, I would like to know for you guys to just tell me quickly the different ways of executing a decree. Faster.
Through attachment.
Who was that? Okay.
Bernard.
Okay, I can't see you, but someone said through attachments. Anyona.
Thank you. So the various modes of execution are provided for under Section 38 of the Civil Procedure Act, including what my colleague had just said. We have delivery of property, we have attachment and sale, we have sale without attachment of debts wherein Ganishi proceedings fall, then arrest and detention, and finally appointment of a receiver.
Okay, thank you. I think you've spoken, or you've said almost all. Okay, fine. So let's go to the question. We have already identified the Ganishi proceeding. So what is the pleading? I think it was Justice or something who said, he doesn't understand why the question says pleading, because for him, he would have done an application. And yeah, they say application is not a pleading. So is there anyone of a different opinion? And if not, I would like someone to clarify if it's an application, which type of application. And then you have to indicate also the reliefs that you'll be seeking. All right. I'm waiting on you people. What type of application? Which are the prayers that you'll be seeking? Yes, Oyo?
Yeah, thank you. So I'll do a notice of motion and a supporting affidavit. But just to be safe, I'll also include a certificate of urgency. The application will be ex parte. The orders are the reliefs I'll be seeking. I'll seek a relief on attachment of deposits in the bank, and that is order 23, rule 2.
Okay, I think it will be good if we read this order 23 for the sake of someone who's hearing this for the first time. But don't panic. Tonight,
Okay.
we are going to do it so easily. You will you will see that Ganishi is such a simple fact. And should it come or should it be tested in your paper, I believe you should score the whole 20. All right, so I'm scrolling to order 23. Just give me a moment. But thank you, Olo. Someone else as I scroll down to order 23. Yes, Evans. Evans, there was a hand up. Evans Ocheng. Okay. I can't hear you, but as you sort out your audio, let me just read Order 1, Order 23, Rule 1. Says a court may, upon the ex parte application of a decree holder, and either before or after an oral examination of the judgment data, and upon affidavit by the decree holder or his advocate, stating that a decree has been issued and that it is still unsatisfied. You note that? So it is still unsatisfied. So I believe when you get to practice, before you go for the Ganishi, first try the other method. But anyways, that's just a by the way. And to what amount? And that another person is indebted to the judgment data and is within their jurisdiction, order that all debts other than the salary or allowance coming within the provisions of Order 22 to 42, owing from such that person, hereafter called the Ganishi. So the Ganishi is someone who owes the judgment debtor money. This is the person that you are going to get the money from. So essentially, I won't read the whole thing, but Order 23 Rule 1 is talking about an ex parte application. And that's what Pew said. He will make an ex parte application and he will be seeking prayers to attach. But if I may ask, have we heard this thing about Ganishe, Order Nisi and Order Absolute when it comes to Ganishi proceedings? Anyone was heard such terms? Anyone? Order Nisi, Order Absolute? Yes, Evans. Evans, your hand is up. Okay. Oyo, I see your hand is up.
Yes, if you read Rule 1, Sub Rule 4, it gives us the form, which means that it anticipates that we will first get an Order Nisi. I think an Order Nisi is given for a period of time to allow the judgment data to satisfy the decree. And if that does not happen, then an Order Absolute may be given. I'm just lifting it from what we used to see in matrimonial courses, where there was a decree nisi in divorce cases and then a decree absolute. But I stand by that.
Okay. Evans, your hand is up. Evans, okay. I can't. Evans, can you hear me? Oh, it's Elijah. Sorry, Elijah.
All right. When you talk about Order Nisi in Ganishi proceedings, We mean that it's an order which is made by the court to the bank, communicating that unless there's some sufficient reason why the bank cannot or should not pay the decree holder, then it's required, the bank is required to actually pay money which are held in the judgment debtors account. So it's maybe in simple terms, it means that the order is going to the bank. For instance, in this case, it's Mkulima Bank Limited. So it's going to the bank. We are asking you maybe to make a communication that is there any sufficient reason that maybe is going to bar that bank or to stop that bank from paying the money which is in the judgment debtors account to the decree holder, of which now the bank will be required to make a communication if maybe there's a reason, or if there's not a reason, then the bank will give out the absolute, the absolute order to the bank so that the money can be released.
Okay, thank you, Elijah. I think your explanation is on point. Now, remember in this question, you have been asked to draft the appropriate pleadings and you have to indicate the nature of reliefs you'll be seeking. So we have gathered that I think we are all in agreement that we are going to come through a certificate of urgency. And there's someone who said certificate of urgency, and then he said to be on the safe side. But the purposes of a certificate of urgency is because you are telling the court, you want the court to certify your application as urgent so that you can get orders quickly. So sometimes you can make an application through a certificate of urgency and then the court will not certify the matter as urgent and give it a hearing date. Now, remember, this is an ex parte application. I just want to explain so that you can understand when you're doing an application if you need a certificate of urgency or not. Remember, this is an ex parte application. You want orders ex parte. That is why you are moving with a certificate of urgency, because in a certificate of urgency, if the matter is certified as urgent, the court will always issue orders or directions on the applications, as opposed to, if it's not certified urgent, it will be given a hearing date, so you'll have to wait longer. And maybe this is something that you really need. Maybe you need some interim orders. That's why people move through certificate of urgency. And that's to all applications. It's not limited to this question. I hope I have not confused you people. We good on that explanation on certificate of urgency? So in a case where you are seeing the application needs interim orders, it is always appropriate to move with a certificate of urgency. Yes, Elijah, your hand is up. Oh, it's down. Okay. Okay, so that's why we're moving with a certificate of urgency, because we want an order, maybe an order missing, and then notice of motion and a supporting affidavit. That is not contested. But now, what I want to gather from you guys so that you move to the next question is the nature of reliefs. Someone said attaching, but yes, you are attaching something, but there's a term. Mutechi Frank. There's a term, and we have just spoken about those terms just right now. So that's a hint.
I think it would be a Ganishi or Danisi for the attachment of the money held by the bank, which would be the second, the second respondent in our application, so that they can either partially or wholly pay, the debt that is owed, in terms of the decree that is, that is in favor, that is, that has been awarded, of the decree total amount that has been awarded in favor of Tom Pila. And secondly, there could be a Ganishi order to, there could be the Ganishi could be ordered to appear before the court to show cause why they would not be able to pay the decree holder the amount of the money that he requests, That is under the reasons why they would not like release their money to the degree holder.
Okay. So you said Ganishi order Nisi attaching the monies in the bank and for the Ganishi to appear in court. Okay. Fair enough. Anyone else? There are some other reliefs that you can, prayers that you can seek. Is there a hand up? Oh, yes, Winnie.
What about a Ganishi order absolute?
Yes, Ganishi order absolute. That's also, in my opinion, that I would seek both order Nisi and absolute. You know, it's the court that will determine the time that it's giving those orders. But for you as a person that is making an application, you have to seek for both order Nisi and order absolute. And then there are some two other reliefs. Okay, let me put it this way. I don't know if you guys have a sample of a Ganishi application. Let me presume that you have. If not, you let me know and then I can share in the group. Yes, Oscar.
Yes, actually, I have a sample with me here. I don't know if you'd allow
Okay.
me to read the orders.
It's okay. It's okay. You can proceed.
Fine. The first order, of course, relates to certification of the application as urgent. But the second one is, this honorable court be pleased to issue an order nisi to the Ganishi to show cause why the first respondent's account with them should not be attached in satisfaction of the applicant's decree. 3, this honorable court be pleased to issue an order for the attachment of the first respondent's bank account with the Ganishi to answer and or satisfy the decree issued on 19 August 2017. The last prayer before the prayer for costs. This honorable court be pleased to issue an order to the Ganishi to pay over the amount of 20 million shillings plus interest at 12% per annum accruing from the date of judgment to the date of payment in full to the applicant herein to satisfy their decree. So that's how the prayers look like, Victoria.
Okay, thank you. Yeah, so I think I just wanted for you to know the first prayer is usually about the application be satisfied as urgent and hard ex parte in the first instance. Then the second prayer is for the order Nisi, but remember how you word your words. There was someone who had talked about a prayer to have the Ganishi come in court, but as if you have heard correctly how I think it was Oscar has read, it was that a Ganishi order needs to issue ex parte attaching so that to the first respondent to show cause. Already when you have made a prayer as like that, you don't need again to say that he needs to come in court because you have already said that he needs to show cause. And then there's the order absolute and cost of the application. Yeah, but I've just realized we did not, or rather I did not ask you guys about how you are going to, to write the heading, which is quite important of your application, which court you are going to. That's something that I didn't ask. So the heading of the any pleading. So I want you guys to tell me which court are we going to, the name of the parties, and you tell me how you'll write it. Quick one, then we move to the next question because I believe we have discussed this widely. So let's do where we're going to court, the parties, then we move unless there's any question. Yes, Jura.
Yes, if I may, I have a question regarding
Yes, proceed.
Regarding order Nisi and order absolute, and
Okay.
how we frame that in the prayers. My understanding is that when you're making the application and upon the lodging of the application, you are issued with the order nisi. So would it just be proper to have a prayer that the order nisi be made absolute? Would that suffice instead of having a separate prayer asking for order nisi and again another one asking for absolute? That is the question I have.
Okay. Let me understand your question properly. You are asking, can you kindly repeat so that
Yes,
I
I'm
get?
asking. My belief is that when you're making an application under Ganeshi things, you do there is the prescribed form that talks about order nisi, which actually invites the Ganeshi to show cause. And I think it is granted the same day, or you can draft it and the court confirms it the same way we do to summons. In which case now, in my prayers, for me, I would think it is proper to say, as one of the orders you are requesting, that the Ganeshi order nisi be made absolute, instead of having segmenting them as separate prayers. So would it be proper to move the way you have suggested?
Okay. If I'm getting your question correctly, you are moving with the presumption that you have made an application and you have gotten your order nisi. So then you're making another application to make order nisi absolute. Is that what you're saying? If I'm getting you correctly.
Let me say,
But
for example, when you've when you're filing pleadings in court, it is always a normal procedure that you also file a summon that the court can sign and stamp, which you can now go and serve the other party to enter appearance. In this instant case, I was thinking the same direction, that when you are doing this application, you also file the Ganeshi orders, the order nisi, that is, because there is already a prescribed form to it. Then the court will execute it, sign it and stamp it. And now that you will get it the same day you're filing this document, hopefully, instead of now asking the court as one of the orders to grant you order nisi, you simply ask the court now to confirm order nisi to be absolute. Like now we move from order nisi, we made absolute. So the question I'm asking is it proper with the direction I've taken?
Well, I will just answer you this way. I think the way you are saying there is a form or like there's a standard form. The standard form is for the order nisi and order absolute. I think those are the ones that have a form that is standard. But your application, it's you that moves the court. So remember, let me just give you a different illustration and then I connect it with this one. Let me illustrate like this. Remember when you're doing an application, say for temporary injunctive orders, let's go to an ELC case. You want to do an application for injunctive orders. You've seen those prayers that prayer number 2 says temporary injunctive order do issue pending the hearing of the application, and then there's pending the hearing of the suit, but it's those two prayers are in one application, and the court can grant prayer number 2, and then maybe prayer number 3 says it might be pending until the suit is determined. So similarly here in a Ganeshi proceedings, when you are doing this application, you know legally that an order nisi comes first, then an order absolute comes second. But remember, you don't want to spend so much time making an application for order nisi, then you get order nisi, then you come again and move the court to get an order absolute. It's not that you will not succeed when you do that, but someone who made an application seeking all of those prayers it's easier work. And you see, sometimes even CLE, they want to test how you know how to move the court. So if I've come in an application, I've already sought for prayers for order nisi, I've sought for prayers for order absolute. So what does that happen? If the court grants prayer number 2, which is for order nisi, then the bank comes and maybe show cause, and then maybe their cause is not sufficient, then the court will easily grant prayer number 3. But if an application just has order nisi, then the court has already granted all the prayers that you sought. You only sought for order nisi, you did not seek for order absolute. So the court cannot move itself. You have to move the court. You are the one that's prosecuting the application. So it's much better to seek for those 2 prayers so that it goes smoothly. Have I made sense?
You've done sufficiently, so thank you.
You're welcome. All right, so back to my question. The heading, which court are we going to, and the parties and the name for the parties. Yes, Njeru?
Thank you. And maybe I wanted to, or rather I want to wade into those waters by, was it Jura, into the issue of order nisi, and when you've pronounced yourself on the same, probably this is what I would say, that if you look at under 23 rule 1, there is a requirement for a hearing. I mean, sub rule 2 says at least 7 days before the day of hearing, the order nisi shall be served on the garnishee, and unless otherwise ordered on the judgment debtor. Now, if you look at on the same order sub rule, I mean rule 4, is it? Yes, rule 4 says if the garnishee does not dispute the debt due or claimed to be due from him to the judgment debtor, or if he does not appear upon the day of hearing named in an order nisi, then the court may order execution against the person and the goods of the garnishee to levy the amount due from him, or so much thereof as may be sufficient to satisfy the decree, together with cost of the garnishee proceedings. And I remember you were asking about the prayers we'll be seeking, and the order absolute shall be in Form 17 or 18 Appendix A, as the case may require. So in other words, there must be a hearing for an order absolute to be issued. Now, if you do not request the court to issue order nisi as a separate prayer, but then you jumble them up as he is asking if it's possible, like you make one prayer, but asking that the court be pleased to confirm on the nisi as absolute, then, or maybe saying in one simple prayer without having to separate them, have the court may be pleased to issue an order nisi and confirm the same as order absolute. So then there won't be a problem, because then what if the court, what if the same is contested? What happens when the same comes up for hearing? I think, and then there is a wisdom in separating the two, so that the court first issues this, and then after the hearing of the same, then it can confirm and grant cost, and then it will be extracted as per Form 17 or 18. That was my contribution on the matter. But then you ask a question. I think the court with jurisdiction will be the High Court.
Okay, and Njeru says High Court. George? Oh, but before George, you
Me, I
go.
think I
But
should look at
George,
it.
George,
Yeah,
George, before you.
I'm
Okay, just proceed.
okay. For me, I look at the pecuniary jurisdiction. I'll go with the value that has been given there above, which is 5 million. I'll go with the resident magistrate because the value the value of the subject matter is 5 million.
All right, all right. Those are two. Anyone who has a totally different opinion on that? But before we go to the court, I will just want to state something that can make everyone at peace and understand about these two prayers, Order Nisi and Order Absolute. How do I word them? Do I put them, all of them there? How is the court issuing one order first and then the other one? How is this coming about? So let me just break down the wordings of the civil procedure rules and simplify it practically, and then you see how this goes. It will be much easier if you think about it in a practical way. It will help you know, or rather understand why you are seeking for the two prayers in an application. And to explain what the civil procedure rules is saying is, I believe the person who has a sample, please share that sample of the application in the group for the benefit of everyone. But in the case that you have done a certificate of urgency, a notice of motion, and a supporting affidavit, and then you have filed that application in court, this is practical. So what happens is, because this is ex parte, there is no person coming to file or to oppose the application. So the court will grant you prayer number 2, because prayer number 1 is certification of urgency. Number 2, Order Nisi to issue. So the court will grant you that order. And then you will go extract the order. And then you will go and serve it to the garnishee. After you've served them, now that's when they come and show cause, and then the hearing happens. And then after the hearing, how it will goes, the order absolute is then issued. So I believe after you see that sequence, you will see why the application has to have the two prayers. It has to pray for Order Nisi, which is you will be granted ex parte. Then after you have granted the ex parte Order Nisi, then for the order absolute, the applicant must respond. And that's why we're saying a hearing must happen. And so you must serve them with the Order Nisi so that you can come and seek for your prayer number 3, Order Absolute. So the danger of not having Order Absolute is that your application, after being issued with the Order Nisi, even if you go and serve and they come, you didn't seek for that prayer. So what happens? Tunasema application yako imekunywa maji. So that is simply put. So I believe we are good now. So we have two responses. We have someone who said he'll file it in the High Court, another one in the resident magistrate. I think there was another hand up. Then Ochieng, Hilary.
Okay, mine is a question again. Just wanted to ask on the court issue on where to go. Do you usually go to the court where the decree was issued? For example, let's say if it is a chief magistrate's court, usually just go to the same court, or we have to seek another. We have to go to another court, for instance, now in order to make that application.
Okay, before I answer that question, anyone who wants to try and answer Hilary's question?
I can attempt.
Yes.
Okay, so ordinarily for execution, you're supposed to go to the court that issued the decree, but there's an exception. So if the court that issued the decree sent you to a different court for execution, you should apply to that court. However, there are certain preconditions that need to be satisfied for the court to sort of order that before they make an order like that. But also based on the amounts that were stated in the questions, according to the pecuniary jurisdiction of the court, it should be the High Court.
Okay. You've said it should be the High Court.
I want to make an attempt.
Okay.
Yes, it's High Court because of the pecuniary jurisdiction.
Okay. But thank you. That explanation of why you go back to the same court. I think that was perfect. You will go to the court that issued the decree. To the person, Hillary, that's the answer. You will go back. If the matter was in the Chief Magistrate's Court, it's the one that has issued the decree. That's the court you're going to go to, unless it has transferred the execution to another court. That's when you go to the other court. So that's perfect.
Okay,
that was answered very perfectly. Haya, sasa we are back to the court. High Court, Resident Magistrate. And for me, I don't know, High Court. The amount is 5 million and 3 million.
Actually,
why
right.
The people who are choosing High Court, why are we going to the High Court?
May I?
Yes, you may.
Okay. I think, well, no, we can't go to the High Court. No, that, okay. So thank you for the response to my question. Now it's clear to me. Then if the decree sum was 5 million, then it only means that this matter was in a magistrate court. And using the pecuniary jurisdiction list, we know that for 5 million usually goes to the resident. Is it resident? Yeah, resident magistrate's court, so 5 million. And then senior resident, it's 7 million. And then, yeah, as you go toward the chief magistrate's court, it's the highest with regards to magistrate's court, which goes for 15 million. And then anything above that, now it's the high court. Not 15 million, 20 million, sorry.
Okay.
Then anything above 20 million,
Yes, 20.
now it's the high court, yes. So for for this instance, I guess you'll just go to the resident magistrate court. Although I've never seen a heading written resident magistrate court. I don't know whether they exist with regards to civil cases. In practice,
Yeah, in practice, you can find a heading in the senior, but most people find it safer to, depending with the nature of the claim. But if your claim is, the amount won't change. You are not seeking maybe say general damages. General damages are to be assessed by the court. So technically, I think in practice, why most people tend to just go to the chief magistrates is most of the time, if it's a general damage claim and you don't know how the court will assess it, and maybe you're saying maybe the court might assess 20 million, so you can't go to the resident because your special damages or the figure that you are seeking is 5 million when you have sought a prayer for general damages. That's just my explanation. But yeah, you might find a heading with residents. But for me, if I was doing an exam, I would write in the chief magistrate's court, because either way, it's still within its jurisdiction. It's not above. Even if it's below, the court will still have the jurisdiction to handle that amount, that figure. But yes, just so that you don't waste too much time, the court is the chief magistrate. So rather, if you want to go to the residence, for me, I would use chief magistrate. It's just in the lower court, not the high court, because for high court, we know it's anything above 20 million. All right, so for the parties, I just want you to name, there is Tompila, there is Sangura Limited, and then there is Mkulima Bank. So Tompila is who, Sangura Limited is who, and Mkulima Bank Limited is who. 1 minute. Yes, Derek.
Tompila will be the decree holder or decree creditor. And then we have
Mhm.
Sambura's the judgment data. Alafu Mkulima Bank would be the garnishee.
Okay. Those are the terms that Derek has used. I'm in agreement with Mkulima Bank being the garnishee. Tompila, any other term that can be used for Tompila and Sangura? Okay, but okay, can be the applicant, respondent. But even if you put the judgment data, judgment creditor, I don't think you will miss marks. Anyways, let's proceed to question 2. I believe we have exhausted. Okay, before Donna you go, but I think we have really touched on garnishee. When the sample is shared in the group, please read it, read the wording, and then attempt. Go attempt this question. Try and draft it. It will help you even to have speed. So go check the sample after you've read and understood who's a garnishee, why we're seeking this prayer. Then go read this question again and draft it, and actually draft it. It will be really helpful. You will thank me when you are writing that exam. Okay, Donna, your hand was up.
I have a question on this, the first one. So we've been
Yes.
told that Tompila is claiming a sum of 5 million, yet the account of this guy has 3 million. Does that have an effect on the question?
Great. You have actually spotted something that we might have missed. So this person has, the claim is for 5 million. This money is 3 million. So what do you guys think? What do you guys think? Anyone who can attempt before I jump in? Yes, Elvis.
I actually didn't see that, so this was really eye-opening. My first initial attempt and thoughts would be that we seek an order to, of course, attach the 3 million. In my opinion, I would make the assumption that it's a company. Well, I was about to say that we could attach their salary, but yeah, it's a company. I'll probably attach their property in this case that could amount to something equivalent to the difference between the 2 million. That's the difference. Yeah.
Okay, so you are saying that we can seek prayers for attaching the 3 million and then also seek prayers for attaching maybe some other things. That's what you've
Yes.
said.
Yes.
Okay. Anyone with supporting Elvis or having a different opinion? Let me see the hands. There is Hillary. Yes, Hillary.
Okay, I support Elvis to some extent, though. First, number one, you can't attach. Okay, to some extent, that in that now that the money in the bank is 3 million and what we are seeking is 5 million, then in our orders, I will frame the orders for one of the orders that we seek. It will be like it should be partly that the decree in absolute should be part execution of what's owed, and then now the 2 million now now that's outside the bank's jurisdiction. Now it's upon you now to go and look for a way how you'll execute the remaining 2 million. So I think the effect will be on how we'll frame, the absolute decree. Is it the decree absolute? How we'll frame that order that when you are seeking it now in the pleading. That's just the difference. And again, now another difference will be now when now the court will be issuing that order absolute. Is it order? Yeah, order absolute. Now that's where another difference will come because it's a different form. I think it's from 16. Yeah, I think it's from 16 of Appendix A because they are different. There's from 16, from 17, and from 18. So that's where the difference will come in. How we'll frame our order for that absolute order and for the forms now. I don't think there's another difference there.
Okay, Pius, I saw your hand was up.
Yes, we have agreed that the question is asking about Order 23, garnishee proceedings. And for me, the bank that is a garnishee only has 3 million, and that is what we are targeting. So I think I want to agree with Hillary that for this particular question, for the application that we are doing, we are only targeting the 3 million. And I want to believe that that 5 million that was put there was just to throw some spanners in the works, to make you think a lot about the 5 million and not the 3 million. Because as you can see, the garnishee only has 3 million, and that is what we are looking for from the garnishee. And then maybe, I think I'll end there. Thank you.
Okay, thank you. And yes, for me, in my opinion, when it comes to garnishee, you can only get the money that they have. If they have 1 million and your decree had 4 million, you can't say, give us the 1 million, then we come for your money. No, because remember, in garnishee proceedings, we are targeting a person who has money belonging to the judgment judgment debtor, sorry. So if they only have 2 million, we can only get 2 million. We can't go and then execute against their properties unless the properties, they belong to the judgment debtor and they are holding it, maybe say, I don't know how to explain it, but you can't go for their property that belongs to the garnishee. No, you can't execute it. You only go to something that they have that is not theirs. They're just holding it for the judgment debtor, or maybe they are indebted to the judgment debtor. That's the money that you go to. So in this question, I think the person was answered how you frame your orders will be good. So let me read you, there's an application I have here, and it says, in my application, we didn't know the amount of money that the bank has. Technically, sometimes in practice, you might not know, or you may or you may not. So this is how it is written. It says that a garnishee or danisi do issue ex parte forthwith, attaching the monies held as deposit or otherwise in the first garnishee, in this there were two, but let me remove the first. In the garnishee account number, this in the name of this, that may be sufficient for the full or partial satisfaction of the decree, and certificate of cost given by this honorable court, now standing at this amount. So it might be for the full or partial. So you might get the whole money or you might not get the whole money. So yeah, I agree with was it Hillary who said that this was just confuse your mind. But thank you, Donna, for spotting it. At least when you spot it in the exam, you will know that for a garnishee, you only get the money that they have. You can't go again and start executing to them. Remember, garnishee proceedings, it's just one of the way of executing a decree. And it is in a case whereby the judgment debtor has monies that is held by another person, the garnishee. So we good. There's a hand that's up. There is Jura. Let's have Jura, then we can go to Angelo.
Okay, that question has actually opened my eyes further to ask this question. There is a
Okay.
requirement. I don't have my rules with me, but I remember that there is a requirement that the garnishee will always give what is remaining after deducting the cost of the application. So where you're making request to have the entire 3 million paid as debt due from the garnishee to the judgment debtor, are you doing so in presumption that his cost, the cost is not going to be borne from what is owing the judgment debtor?
Okay, I have not, or you are saying, you are asking if we claim for the 3 million, you are saying there's a rule that says that the garnishee can only issue money after it has finished with the judgment debtor, or
Deducting the cost,
it has finished.
of the application, because he will come for hearing and all that, and there are cost attendant there too. So I believe under the rule to make appropriate deductions of cost incurred and pay what is due.
Okay. Yeah, so this is, I think we are speaking about Order 23, Rule 10, that says the cost of any application for an attachment of debts and of any proceedings arising from or incidental to such application shall be in the discretion of the court, and the cost of the decree holder shall, unless otherwise directed, be retained out of the money recovered by him under the garnishee order and in priority to the amount due under the decree. Essentially, what you are saying is true. But you see, remember, in our application, we had was it 4 prayers? Yeah, there was the one for urgency and ex parte. There's the order nisi, order absolute, then cost for the application. So for me, I have sought, I want monies in this bank to be attached. I've also sought for the cost of the application. Now the court is saying the cost of that application, it's in the discretion of the court. The court can decide and say you pay the cost. Oh, but the general rule is that that money will always be part of the money that you recover. To say that if you are coming for 3 million, cost of the application is more, it will be more, you'll have to add some more amount of money. So the court is saying generally, if you have recovered that 3 million, that the cost of your application will be catered under that 3 million. But if the court's discretion decides otherwise, it can always direct otherwise. So yeah, so I hope I have responded to your question. Yeah, but let's remember the term saying be sufficient for full or partial. I think that's going to be helpful when you are wording your prayers. Yes, Angelo. Okay, Angela's hand was up, but it seems to have disappeared. All right, so that was in question 1, and I believe we are good. We can now go to question 2. Okay, let's go to question 2. Maybe Alice, you can scroll. Okay. Let me just read. Mary Timber, the deceased, was the absolute and registered proprietor of land known as Shurika 2030, which was charged to Shark Loans PLC. The deceased brother commenced proceedings, succession number 10 of 2019, to administer her estate. The court thereafter issued conservatory orders and subsequently the deceased estate fell into arrears and neglected to service the loan. The deceased brother has refused to remit the monthly rent payable by each tenant to the bank to service the loan. The bank has approached a law firm and informed you that it was not aware of the conservatory orders and was neither party to nor aware of the proceedings or orders sought. Based on the facts provided, advise the bank on the type of application and reliefs you will seek and grounds for such an application. Higher. Let's start. Let's roll. What do you think? What do you think is the application that is being tested here? Anyone, you can remember, you can always attempt. There is no wrong answer. We are all learning. Try and just attempt. Yes, Jura.
While representing the bank, for me, I would go for setting aside of the conservatory orders on account that these orders were obtained what I would term fraudulently or without revealing material fact. So I would ask for the same to be set aside. And
Okay, and which order?
I'll go under order 51. I think there is a rule that grants within it setting aside of ex parte orders granted by court, and the same be done through notice of motion. Thank you.
Okay, thank you, Jura. That's an attempt. So Jura has noted about setting aside of the conservatory order 51. That is his opinion. Anyone else? Anyone else? Anyone else? Do I give you a hint? But no, let someone else attempt and then I give you a hint. I want some, let me read the question again. So that maybe if you catch. You see, Mary was the deceased was the also Mary was this, she was the one of this land. So her brother went and did proceedings, succession proceedings. Her brother went and did succession proceedings. Her brother was the only party in the succession proceedings, and he got orders. The bank did not participate in the case. I think that's a hint. That's a hint. I've given you a hint, so I want you to think which prayers, or rather which application is what question, what is really testing you here? We have seen that yes, Jura.
Would it be talking about order 10? Default judgment?
No. That's not where I'm going.
Then I go back to my original submission.
Yeah, go back to your original submission. There's something that I want you guys. Let me read this part. The bank has approached your law firm and informed you that it was not aware of the conservatory orders first and was neither party to. Neither party. It was not a party to this suit. So how do we help the bank? How do we move the court? Yes, Ruth.
I think the bank will seek to be added as a party to the proceedings.
Awesome. And which party? No, there are so many parties. This third party. So which party? Clarify that.
The bank will seek to be added as an interested party.
Okay, awesome. So there's the interested party aspect, which we are just submitting. If you have an objection or a contrary opinion, please, before we make orders or our conclusion, please feel free to raise your hand and question our judgment. But yeah, so yes, Ruth. Okay. Oh, yes, Pius. Or is it Pius? I'm sorry if I've pronounced your name wrongly.
What is it a name? Nothing. So
Okay.
I would also try and support Jura by going with the order 51, rule 15, setting aside ex parte order. Because
Setting
it's in,
aside, okay.
yes. So that is the
Okay.
application I would make.
All right. So for you, it will just be setting aside. But that setting aside, you are only agreeing with setting aside.
Of course, if you look at the question, the deceased brother has also refused to remit the monthly rent payable by each tenant. So this was a charge, and I would also maybe request for appointment of a receiver.
Okay.
I don't know if that would suffice.
But okay.
You can.
Let me first say this. I think in this question, you remember, okay, in this in this question we have not been asked to draft. We have been told to advise. So let us first remember that. So we are advising the bank. Please read the question. You know, sometimes you can be reading faster. You've already seen, it's this a notice of motion. You've already started drafting. Please, that's another thing that I will also tell you to be very keen. When the question says advice, it's advice. Don't start drafting. It's advice. You can even choose to write a legal opinion because you are advising, you are not drafting. I hope you are good with that. That you don't go to the exam. You've seen this application. You have started drafting. You are missing the point. But anyways, that was just a by the way. But then I want to I'm agreeing with those who are saying setting aside. I have no problem. But I want first for us to know. Yes.
Again, for the last time,
Someone.
I'm asking if I can come back last time.
Who's that who's speaking?
This is Jura.
Oh, okay. Okay. Just proceed, then I'll continue to make my submission.
Borrowing from my law succession, and again from what there's a lady who spoke before Pius. I also think that maybe the bank would come in and claim that being a creditor, because if you look at the manner in which the suit property was charged, that means the bank in this circumstance was a creditor. So the bank would then make an application and come in as a bona fide beneficiary on that account of being creditor, and we make a claim to benefit, to be paid, the liabilities that are due. So one way of, approaching the court, and now that we were talking about reliefs, is to ask the court to, if there are orders that are prejudicial to the bank, then the bank can ask the court to set aside those orders and be listed as one of the creditors in the liability schedule of liabilities. That would be my further approach to it. Thank you.
Thank you. And okay, as I was saying before, for me, the first approach, Jura and who was the other person who talked about setting aside the default order and all this thing about the bank being, a creditor, those are perfect and they are correct. But I want you first to remember we are Number one, we are in a civil litigation exam. So the first approach should always be, you see, you should mark that part was neither a party and realize this examiner wants to know what happens if proceedings occur and that affect you and you are not a party to that suit. What do you do? What do you do? Are your hands tied, or can you move the court? And if you move the court, through which application? And if you go through that application, which price are you going to be seeking? Because I think essentially, even if you want to set aside an order, this is a question: can someone who's not a party to a suit really get orders? You know, if you look at it at that, then you will see that my first approach should be, I should first ensure that the bank is a party to this suit. So you are advising it, you know, you have to, and this is how you are telling them you have to be a party to the suit, because, you know, for you to get these other orders or for the court to hear you, you have to be a party, and you will be, say, interested party, and who's an interested party, what are the grounds for you to be an interested party. And then after you've told them how they are to be a party, then you tell them, after, you can also seek for these other prayers upon, so that now you say upon your this prayer being granted, the court can then now move to granting these other prayers. But the first thing, you should make sure that you are a party to the suit. And this is just to the answer this question. So we will go directly. What are the grounds for someone to be, for making an application to be an interested party? Because we have already gathered that this bank was not a party. We have to make it a party. And as Ruth told us, the application for an interested party. So I want to read the order. So which is the order that you move the court to the application, and what are the grounds? What do you have to show the court for the court to be pleased to make you as an interested party? There's Anyona.
Sorry, if I may take you back kidogo to when you're talking about application to be added as interested party. I'm wondering, because we've been told that the case was, I think, concluded and there are conservatory orders. I'm reading it wrongly. So I'm really wondering if you can make that application once a case has been concluded. You may want to educate me on that.
Okay, I have not read where the case has been concluded, but let me read the question again. The deceased brother commenced proceedings to administer estate, and then the court thereafter issued conservatory orders. Anthony, where have you read that the proceedings or the case was concluded? But that is also, we can always answer a question: what happens if a case is concluded? How do you then move a court? Do you come and say, I still want to be an interested party, but the court we already dealt with this matter, so what happens? Okay, in this question, I don't think the case was concluded, but now let me put your question back to you guys. If, let's say, if in this case the suit was concluded, how do you move the court and you are not a party? Will you still come as an interested party, or your hands are tied, or what do you do? Anyone? Anyone who has an idea? What happens? You are not a party and the suit has been concluded. Maybe there was a judgment. Is your hands still tied, or are your hands tied? Yes, Jura.
Going by your explanation, I see you are driving us to join the parties, and considering that the suit has been concluded, I don't know whether a review will be an appropriate way, and going by the ground of sufficient reason. And the reason thereof for me would be the fact that you are likely to be prejudiced by the same orders, and your right to be heard was not granted.
So you are saying you would be seeking for what?
To be added as a party. Of course, I'll make, for me, I would go with more of a judicial review under Order 45, but also, I don't know whether you can mix up orders so that I go under Order 45 at the same time I add Order 1, which talks of joint of parties, so that I'm asking for review on the account that where under the review I'm going to ask for setting aside, and at the same time as I'm asking for joinder of party. That is the approach I'm thinking about.
Okay, so you are saying you will still want to be added as a party. And I think what I think the question Anthony is asking, let me reframe the question, is can you be added as a party
Sorry.
after a suit has been concluded? That's what
Sorry, Victoria.
Anthony and yes.
Sorry. This is Anyona, not Anthony.
Oh, it's sorry. I saw and I just my mind rang Anthony, but sorry. Anyona, correct? So Anyona is asking, can a person be added as a party if a suit has been concluded? I think that's your concern, right?
Yes, yes.
Okay, sorry. There was Ruth. Ruth, your hand was up at some point.
Okay, I think after the case has been completed, you have to approach court. Okay, through an application first, maybe to set aside the judgment and the consequential orders, and maybe if the subject matter it's something that was detrimental to you, so maybe you did not like have a chance to defend it. Now I'm confused, but I think if if you are not served with the let's say proceedings and yes and the notices, maybe you be okay. I don't know. It's time to be guided because I'm now confused. Since like, will you request the court to reinstate the case or okay?
Okay, let's hear George. Okay. George, we can't hear you. We really can't hear you. Okay, I sort out your audio, Angelo.
Okay, I don't know. Can I be heard?
You're a bit faint. Come again. Oh.
All right, I'm saying, can I be heard? Or I'm having the same.
You're having the same issue with George.
Okay, I was in the next.
Okay.
Yes.
But okay, maybe
However,
the rest. Can you guys hear Angelo? Maybe a thumbs up can indicate the same.
We are struggling too.
Or they're also struggling. But Angelo, just proceed, and then George will also struggle. Maybe it's okay. Higher.
Yes, you are saying I can proceed?
Yes, I think now you are a bit clearer.
All right. What I wanted to say is, in fact, it is a good
question, the question by Anyona, you see sometime when the case has been concluded, a party can make an application to revive or to reinstate that particular suit. But the question, therefore, is if you are not a party to this suit, how then do you even come and let's say make that particular application? Because remember, you have no locus to even revive that suit from the beginning. At least the question that we have now, the one that we are answering, you can make that particular application to be joined as an interested party. But because you see the jurisprudence now from the Supreme Court, you see a court cannot make an order that is going to affect a party which was not a party to that suit. How do you make orders for someone who has not participated or who was not joined as a party to that particular suit? So you see it becomes an issue. Okay, so courts are restrained from making those particular orders. Only parties to the suit can be affected by the orders of the court. Okay, so Maken, I don't know if this person would have even locus to actually make an application for a statement of a suit from the beginning. Maybe it is something that you can guide on. Thank you.
Oh, sorry. I was muted. I'm saying thank you, Angelo, for your sentiments. Ruth, is your hand up, Ama? It's an old hand.
It's now up. So, okay, in regards to what the last speaker said, in order to come to court, okay, if you're going to reinstate the case, it's because whatever was ordered, it means, okay, you are definitely not a party, and maybe because you are not served or informed about the case. And meaning, if you're coming to court, you're coming because you have locus, because the subject matter of the suit affected you. Let's say, for example, in this, the suit property, like the PLC, this Shark Loans PLC. They have locus because the property was charged under their name. So they also have a cause of action, I think. Okay, what I'm trying to say is, in as much as the case has ended, I think a party who was not initially a party to the suit can come to court and seek relief because the orders are detrimental on them, and it's only because they were not served. So suppose maybe in this regard, this one will come as an interested party, and maybe, for example, in the first statement that I was saying, maybe they are supposed to be a respondent, so they'll come back and say maybe they should be reinstated. They be given leave to put a defense if they are supposed to be a defendant or respondent. That's what I can say.
Okay, is there anyone who wants to give their sentiments before I now give my... Yes, there's Alice.
I'm seeking a clarification in line of what the last speaker has said. Do we even have a defendant in this case? Because the only thing I can see is we have the deceased brother who commenced proceedings, but who will be our defendant in this case? Or is it the conclusion that succession matters do not have defendants or respondents? Because I don't know how we can have an interested party if we do not have a defendant. So who is the defendant?
Okay. So Alice has raised another question, but Alice, before I answer you, there was a question that Nyano had raised on whether you can become an interested party or whether you can move a court to be an interested party if the suit is concluded. And my answer is no. If a suit is concluded, you can't like move the court. You have no locus. And I will share you there are case laws to that effect. I'm not just thinking in my mind. There are cases that speak to that for you to be enjoined to a suit, the suit must be alive. Once we finish this session, I'll share it in the WhatsApp forum. But you can't. The suit must be alive for you to make an application to be an interested party. As Angelo said, you can't even revive something that you are not a part of. So interested party application, the suit must be alive. And this is one of the grounds, I think, for such an application. Higher. So I think for that we are good. And Anyano, in this case, this suit is not yet concluded. Conservatory orders are not, how do I say it? They are not conclusive orders. Conservatory orders, they can say, maybe this to happen. This, if you see, in this case, I believe the conservatory orders was that maybe the deceased estate should not be tampered with, something like that. But in this case, in our scenario, the suit is still alive. We have not been told anywhere that it has been concluded. Only we have been told conservatory orders, and conservatory orders are not conclusive. The suit can still be alive with conservatory orders. So I don't know. I see your hand is up.
Yes, thank you, McKenna. I'm guided. I'm supposed to have misread the facts. So, and once again, my name is Anyona. Thank you.
Oh, I'm so sorry. I'm so sorry. I keep getting your name wrong. Apologies. Maybe you can tell me your other name. The Ayona, maybe my mind is not clicking, but anyways, I'm also guided when it comes to your name. So yeah, so there's that. Alice was asking, there's no defendant in this case, so how can there be an interested party when there's no defendant? So I want you guys to answer her first before I proceed. Can there be an interested party without being a defendant? Without there being a defendant, yeah. Is it a must for there to be a defendant so that someone can be an interested party? Someone to just answer that. Yes, Donna.
Okay, for me, I don't think there has to be a defendant for one to be an interested party. As long as the orders or the rule judgment that will be issued by the court will affect you, then you can just go ahead and apply to be an interested party. There doesn't have to be a defendant.
Okay, yeah. Thank you. So we have to understand who's an interested party, so that you be able to know, is there a defendant? How do I know this one is an interested party and not a defendant? An interested party is someone who was not at the party at the beginning or at the stage that was being filed, but the proceedings in that case will affect them. So for an interested party, you might not have been sued or you may not have sued, but the proceedings in that case will affect you. That's why you might find in some petitions, this constitutional petition, you find some people they are seeking to come in as an interested party. Others they want to be joined in as amicus curiae, So what is the difference? Well, an interested party, why are they applying to be an interested party and not an amicus curiae? So interested party is a person who's claiming that the judgment, the proceedings of that case will affect them. So that's why I think this question is also asking you grounds for such application, because as an interested party, you just don't become an interested party because you want to. You have to show the court that proceedings will affect you. I think there is a definition. Let me read you for this definition. It's in the Mutunga rules. It says, it defines an interested party as a person or entity that has an identifiable stake or legal interest or duty in the proceedings before the court, but is not a party to the proceedings or may not be directly involved in the litigation. That's one aspect of it. And then in the famous case of Momo Matemu, it says that an interested party is one who has a stake in the proceedings though he or she was not party to the case ab initio or from the beginning. He or she is one who will be affected by the decision of the court when it is made either way. Such a person feels that his or her interest will not be well articulated unless he himself or she herself appears in the proceedings and champions his or her case. So that's an interested party. So when you are thinking, is this person an interested party, you look at it in that particular aspect. Also, you know that someone can be joining the suit as, you can want to be joined as a party. You cannot be sued, but you can come and say. But I think if you are not in the suit ab initio, I think the proper addition would be as an interested party. That is my opinion. Because or you can also be joining as a defendant or as a plaintiff. It depends. So by the way, in this case, is this person coming in as an interested party, or are they coming in? Remember, this is succession. There was juror said that they are going to be a creditor. So let me even ask, maybe I might even be wrong. Could the bank come in as an interested party, or will they want to be added as a party to the succession proceedings? Maybe come in as a protester or what? An objector? Those terminologies in succession. So, Angela, I see your hand is up.
I can confirm it is not an all and. I wanted to contribute to the discourse when you were discussing on the grounds for joinder. And it is something you can find under Order 1, Rule 1, Order 1, Rule 3, Order 1, Rule 10.2, then Order 1, Rule 7. So there are about 5 grounds under which a party would be joined as a party to that particular suit, okay? For example, Order 1, Rule 1, so all rights in proceedings are in respect of the same or series of transactions. For example, in this particular question, or even if he is a creditor. So you will see from that series of transactions, there must be nexus between these particular parties, because a stranger cannot just come and say that I want to be joined if, let's say, the orders of the court are not affecting you in any way. Okay? And for example, under Order 1, Rule 3, there is a common question of fact or law which would arise in a proceeding, that is, if separate proceedings were brought by parties. Because imagine now if there is now another party that would come in. So that it would be really necessary for that particular party to be joined as a party to the suit, either as an interested party, a third party, or let's say as a defendant. A plaintiff can also be joined. A plaintiff can be joined, and also a defendant can be joined in the suit. Under Order 1, Rule 10.2, the presence of any person as a party to proceeding may promote the convenience, that is administration of justice. For example, in cases of vicarious liability. That is why you see a driver then can be sued, and then now the owner of the motor vehicle is brought on board as a party to that particular suit. So there's that aspect of administration of justice. Then finally, a party's presence is necessary as a party to enable the court to effectively adjudicate upon issues, that is, at the same time, administration of justice or as an administrator, like, for example, Attorney General or issues like that. And then finally, Order 1, Rule 7, there is a doubt as to the presence, as to the person against whom a plaintiff is entitled to that particular relief. So I wanted to contribute in that aspect, McKenna. Thank you.
Okay, thank you. So we have come to, I think we have settled down to this question is asking about joint of parties. That's the main thing that the examiner will want to know, or rather to test if you understand that this question is also about testing joint of parties. And we have come to the agreement that those prayers that we, or rather the help that we want to give the bank, the first thing first that we need to do is we have to ensure that the bank is a party to the suit. And so we were, I think I and Ruthie were championing for an interested party. But right now I think we have seen that you can also be added as a defendant or as a plaintiff. So in this case, do you still think that the bank would be better off as an interested party, or does it have a chance, or do you think it should come in maybe as a party to this suit? As according to Jura, who was talking about the creditor. And so any comment on that before we move? Angela, I see your hand is still up. Okay, Jura.
She's a Lowland.
Okay.
Well, I appreciate the contributions, which are quite insightful. The reason why I was coming with the issue of the word creditor, I felt that this being a succession cause, it is subject to law of succession as far as the rules of the courts are concerned. So the rules of probate and administration would apply in the circumstance. But again, if the way I've listened to you explain, and as well as Angelo, then it is apparent that order one would suffice. In which case, then, if I'm going with order one, I think this bank then would come in as an applicant, but seeking that the court be pleased to recall or review and set aside the judgment or orders. In this case, we're talking about ex parte orders delivered on that particular date. And the same be declared, the matter be heard afresh. And you support that with the ground. You are more of an interested party considering the connection between you and the suit property. That is if we go with
yes.
That is if we go with the civil procedure. And again, I would equally import Order 45 because the review issues are well canvassed under Order 45. But my confusion comes in why we would use civil procedure rules when this is a succession matter, which for me, I believe is supposed to be guided by probate and administration rules. Thank you.
Okay. But I would want to tell you that you are not wrong. The bank is a creditor. You are actually correct. It's a creditor technically. When it comes to succession, it would have been essentially if the brother was an honest man in the summons for grant, he would have listed the bank as a creditor, and that was proper. It was a proper, thing for you to say. My point was, we have all agreed that this is about joint of parties, and it's not really about whether we are coming with civil procedure rules or probate. The mere fact that it's joint of parties is what we needed to conclude. But now you have said, you've raised the fact that you don't understand why we are using civil procedure rules in a probate matter. Yeah. But when it comes to joint of parties, when you're in a succession, when you're in a probate court, which I know the probate rules, they have there's a rule in the probate and administration rules which gives the High Court, I think it's Rule 26, if I'm not wrong, that gives the High Court powers to make any, any orders. But I don't know if it has any order, it has any rule on about addition of parties. Maybe I might have missed that. Yes, Angelo, your hand is up.
Yes, I wanted to bring to the attention of the speaker. I didn't quite get his name. Was it Jura?
Yes, Jura.
Yes. You see, Jura, this is a civil litigation examination, and in one of our sitting, I try to correct also one of our members in the sense that we need to restrict ourselves to the question and your understanding of it, because you see law has a lot of possibilities, and if you are going to open up your mind to different areas of interpretation, then you are going to be lost. You'll get lost, and this is how you lose your marks. Okay. So if I were you, I would actually restrict myself to the principle of law under civil litigation, civil procedure rules that I'm being tested on. Okay. And then you proceed. It is like in one of the papers we were revising, one of our members was saying that I would apply for extension of time because the time to file the appeal has already lapsed. You see? But the question is telling you to draft the necessary appeal, whereby you are required to draft a petition of appeal. So whatever that you think that is there, which is actually correct, but just restrict yourself to the question, okay? Such that you don't, because if you will go to the succession law, then you will be moving away from civil procedure because succession has its own rules, okay? So that is what I wanted to say, Gitari. Thank you.
Yes, thank you, Angelo. Thank you for reminding me even to clarify that part. When you are in a civil litigation exam, sometimes you might find even the facts of the question, they look as if you are in a conveyancing exam because the facts about land, and you're like, oh my God, what? But don't. As Angelo has said, law is very wide, and they can so many things. You can have very many solutions. So, and as I said, when you are looking at a question, the first thing you should ask yourself is, what is being examined in this question? Which area or which unit or which topic in civil litigation is being asked? Where am I supposed to take my mind to? And so in this question, remember the first time I was asking you which type of application, which orders, and several people were talking about setting aside, and I was like, yeah, that's legally speaking, it's a correct thing to do, but we must focus on what the examiner wants. The main thing is he wants you to realize that this person is not a party, so joinder of parties. That's the first thing. So you see, when it says advise the bank on the type of application and reliefs you will seek, when you're advising, you'll be advising about, joinder of parties. You'll be telling your bank why you have to make an application for them to be joined as a party and what are the grounds for that. And then maybe you can now talk about the reliefs. And then the relief, that's why you can expound and shine in your legal knowledge of how much you know those orders. But remember, the main thing, always focus on what the question is examining. What is it? If it's joinder of parties, don't focus so much on, oh, it's a succession claim, what am I going to do? Just remember you're in a civil exam and you are talking about joinder of parties and sail through nicely. So I believe there is someone who actually talked about the grounds for making a joinder of party application. And I think here about the reliefs we have expounded sana. So unless there's a question, I think it is safe to proceed to question 3. Let's go to question 3. Okay. Alice, maybe you can scroll down so that it can start from question 3. Yes, there, good. Okay, Munyo, there's a Munyo. Maybe you can read for us that question.
Okay, question 3. You can hear me?
Yes, yes, you can.
Okay, question 3. An application has been filed in court by the plaintiffs, Joseph and others who are officials of Kibos Forest Association. The orders sought are that the respondents who are also defendants in the case, Kibos Forest Service and Kibos Millers Association, be restrained by themselves and or their agents from harvesting timber and fuel materials in Kibos Forest within Bot County, pending hearing and determination of the suit. The grounds upon which the application is based are that the respondents are not qualified to harvest timber, the forest rules have not been adhered to, that the allocated sawmillers are over harvesting the trees, that Kibos Forest Association was not involved when allocation for cutting trees was being done, and this is contrary to the forest rules, that there is no harvesting license issued and no environmental impact assessment has been done. The plaintiffs aver that they stand to suffer untold loss as they also depend on the forest for their livelihood. The plaintiffs further state that the environment stands to suffer irreversible loss if the harvesting of trees is not stopped. You have been retained by the plaintiffs in this case. Draft the submission that will be used to argue the application, stating clearly orders sought by the applicants.
Thank you. All right, so this question is about drafting submissions. But before you start panicking, oh my God, which submissions? What am I going to say? The easiest way, or rather the easiest way that you can look at this question and be able to stay calm is, first, what is the application seeking? What kind of an application is that? Maybe that will guide us into, seeing how we are going to draft these admissions of ours. So, as the application has been listed in the facts, what type of application is this? And what orders are you seeking, so that we can be able to now move from there? The orders. This application is seeking what kind of orders? What? Okay. Yes, Jura.
I think these are injunctive orders, or what we call interlocutory injunctions.
Great. Yeah. David, I believe you had the similar answer. Okay. So these are an interlocutory orders, or as Jura has said, injunctive orders. So we know there are the 3 grounds for an injunctive order to be issued. Right? So let's state the 3 grounds, then I'll explain why it will be very useful for you to have that. Or let me just explain. When you're drafting submissions, it has to consist, the easiest way, or rather the easiest way for you to flow smoothly, especially in an exam settings, is to draft the heading, the brief introduction, the issues, and then the rule, and then application, then your conclusion. So, obviously the brief introduction, you are for the plaintiff. So, Your Honor, we act for the plaintiff in this case, and we submit our submissions as follows. Then you proceed to give the introduction, what the application is about. And then you have to go to the issues. So let me first go, what are the issues to be determined in this case? And then when you're going to the application, that's when I will ask about the 3 grounds. What do you think are the issues in this application? The various issues. All right, there are people who have not spoken the whole time in the meeting. Uh, at least speak. Let me see. Let me just choose. Julia, you've spoken too much. You need to drink some water. Let me choose someone else to speak. Even Pius, you've spoken. I want someone new at least, just or someone who has not spoken as much. No, it's good to participate. Okay. There is no new hand, so I think I will choose Jabet Milka. Are you with us? You can even say anything concerning the question if you are around. Okay. But I hope those who are silent, I hope you are following. I hope you are following. Don't just, yes, there's Nicole.
Okay, so there are a number of issues, but most of the issues that I'm seeing are factual issues. But an example of one of the issues would be whether there will be irreversible harm to the environment. So essentially, whether the applicant's rights to an environment would be violated.
Okay, thank you. That's one of the issues that Nicole sees. There's who else raised their hand? There's Evans. Oh, Evans. Evans, are you speaking? Can't hear you.
Can you hear me?
Yeah, I can.
Okay, so I think the first issue should be whether they've established a prima facie case, which based on the facts, I think we can conclude that they have.
Okay, so whether they have established a prima facie case. Great. That's a good issue. Jura, finally, you can now speak. I think the water has, you've now drank water.
Okay, I also align myself to the issue already identified by Ahamo. The second issue I would raise here is whether the plaintiff would suffer irreparable damage that cannot be compensated by way, that cannot be sufficiently compensated. That would be my issue number two. Lastly, probably I would raise the issue who bears the cost of this application.
Great. I think that's a fair analysis. So when the reason as to why I was asking you which type of application is this, and then I was like, what are the three grounds for you to get an interlocutory or for you to get an injunctive order? You need to show that there's a prima facie case with a high chance of success. You need to show that you will suffer irreparable harm, which cannot be sufficiently compensated. And then there's usually the third one. I'm trying, where am I forgetting this term? What's this term? Can someone remind me? Yes, Nicole?
The balance
whether
of
on a
the
balance of convenience it falls
yes.
on favor of the applicant.
Perfect. You see how you guys are smart. Yeah. You're very smart. Yeah, so that's the third one. So when you identify this application is seeking for injunctive order, so what does the injunctive order, what are the grounds for me to get an injunctive order? This and this and that. So you need to look at the facts and then you submit. So I believe we do understand what prima facie case means, but there's a famous case. There's a famous case law that you cannot miss to use in your submissions in this question. And which case is that?
Giella versus Cashman Brown.
Good. So that's the case, that you even have a case law to support your submissions. Imagine, smooth. So you remember you're for the plaintiff who we also have to think to remember also in these submissions you have to have a heading. Which court we are going to, who are the parties, how do you write the parties? So I think we have spoken about prima facie, irreparable harm, balance of convenience, and that I really can't go submitting saying how you will submit on a prima facie case, because that is just how you will have your understanding. So if you know about what a prima facie case, it will be very easy for you to say why these people have a prima facie case with a high chance of success. Irreparable harm, they have even told you already. They depend on the forest for livelihood, and if this forest is they have it's irreparable, how can you refund someone money? That's why they get their livelihood. Okay, so I think that is just it. But first, let's start before we go to the main body. Let's start. An application has been filed in court. Remember, you will not start drafting submissions like kienyeji. You need to have a heading. Republic of Kenya. In which court? In which court? So let's see. What do you think, which court this matter would be? And then the parties. I want you to tell me there is this plaintiffs and then there is this respondent. So I want you to tell me which court and the parties, how you will draft them. Which court are we filing this matter? Or which court has this matter been filed? Where will you write in which court? Or you will be just Republic of Kenya in dash? So that's the question I'm asking. Anyone? Yes, David.
Yeah, this suit will be in the Land and Environment Court. Now,
in the what?
as to whether it is Environment and Land Court.
Yeah, yes.
I think the brain is starting to shut down.
You're almost through.
Becoming okay. So I think that is now you can file, assuming it is in the Chief Magistrate's Court, then it will be in the Chief Magistrate's Court. Because I think we've been given the jurisdiction. This is a public land. So, but we can still protect the interest in the Chief Magistrate's Court. So I would have gone for that.
Oh, so is it environment? So you will not go for the ELC, the High Court. And true, let me say it's true, the Magistrates Court also handles ELC matters, where the jurisdiction, where the pecuniary jurisdiction is still under 20 million. But I think for me, in my opinion, when you have such a case, you see it's a land matter, there is no amount of money issued, just go with ELC. But even if, because technically there's nothing that can show you this could have been in the Chief Magistrate's Court. All you know is that it was a land matter. So just go to the Environment and Land Court. That will be my advice. Higher parties, there is the plaintiffs and the respondent. Since this is an application, remember the plaintiff will be the plaintiff applicant and the respondent will be the defendant stroke respondent. Higher, then you title submissions and then you go introduction. This question again, another thing, when it comes to civil litigation, I didn't tell you when I started, when we started this discussion, but civil, sometimes you might find it has a lot of drafting. So one of the ways that I can advise you is when you are doing revision for civil, the day that you have said, today I'm doing civil, as you study, draft, just draft, practice makes perfect. So in this question, I think us knowing which court and knowing which type of application and knowing how you can, how do I say it, arrange your submissions. And as I have told you, brief introduction, issues for determinations, the rule, and we both know the rule for injunctive orders. If not, someone can just shoot that. Which is the rule that grants interlocutory? I think it's order 40. The civil procedure rules. Anyways, that's it. So you talk about that rule, and then you go through the application, you argue, you submit on the issues, and then you conclude. Yeah, so in my part, I don't know how much to answer this question or rather guide you, but that is the much that I can guide you. Yes, Angelo.
Yes, thank you, McKenna. It is just to reiterate in 30 seconds, and maybe I have stated this more like 100 times in this forum. The structure is really, really important. Okay, once you have identified your code, your caption, by the way, you have caption alone there, you have like 2 marks. So the structure of your submissions like us about even half of the marks, maybe even 5, and the content will take the other. And once you have mentioned that Giela versus Casman Brown, and I believe there's a Kenyan case, you don't even need to do much. So like the way McKenna is saying, you just like you structure, if you have got that one right, uko tu sawa, because the marks start from there. Okay, so that's what I wanted to say, McKenna. Thank you.
Thank you, Angelo. Yes, you have actually buttressed my point. So remember, structure, how you structure your work will come through for you. Sometimes you may not even know really the prima facie case. So when it comes to draft work, just know the court, know the parties, and structuring your work. So in submissions, there are things that you are persuading the court. So as long as you know how to persuade and structure your work, you will be good. So I believe we can move to the next question. Is it this one? Oh, it's 6 questions. I was trying to, I wanted us to, we finish this whole paper today. But let's see. Question 4. Let me read quickly so that we can move fast. Yeah. The following is the status of a brief you are handling on behalf of Wakili ET and company advocates, having been retained by Mary, the plaintiff. Mary has a child and is struggling for upkeep. Mary needs help in catering for medical expenses, school fees, and food. The alleged father, James, the defendant, is a man of means who can comfortably provide for his estranged family. Jaden, the son, is in school and is about to do the final examination. His evidence is needed in this case and is necessary for a just determination of the case. Jaden's school is in Mombasa and the case is in Malaba, which is about 400 kilometers away. Your client does not want the child's school program to be disrupted by going to court to give his evidence, and this is a fact he will make known to the court. The person who signed the birth certificate, George, is required to give the evidence in court. He has indicated that he cannot be available, but he has availed a certified copy of the birth certificate. The advocate for the defendant has no problem in dispensing the presence of George. The plaintiff has availed, has availed the following original documents, which will be used as evidence in the hearing, namely school fees, invoices as evidence of arrears, birth certificate, and paternity test report. According to the defendant's advocate, they will not object to their use if they get an opportunity to see the documents and confirm their authenticity. His client is also anxious to have the matter expeditiously disposed. Apparently, the defendant had lodged a notice for inspection, but the plaintiff had not responded. A case conference date has been set. Advice measure on the directions that are likely to be given by the magistrate presiding over the matter. And then B, distinguish between a case conference and a trial conference. All right, so obviously this question, we know what it's testing, so I will point it back to you. But it's in the facts. We know what this question is about. But I would just like to hear your views. What do you think when you're advising? What will be your approach? And then we can go to the, what the question is about. Okay. I hope your brains are not shutting down. I am just hoping so. But if you are here, let's try and move. I believe we all want to finish this paper. That was my desire. I wanted us to do all the 6 questions. So anyways, let me just point out this question is about case conference. So what happens in a case conference, or what is a case conference? Maybe that can guide or help others to know how they can advise Mary. So what's a case conference? What usually happens in a case conference, under which order? I think that's the kind of approach that you should look. At least 2 responses, then you can try. Anyone? Elijah, what do you think? Yes, Anyona. Oscar.
Yes, if I may, you asked about the case conference or case management, and it's provided for under Order 11 of the rules. Yes, I don't know what else you asked about.
Yes, okay. I'm asking, remember, this question has told you to advise Mary on the directions that are likely to be given by the magistrate. So I'm asking you people, what is, for you to be able to advise Mary, you have to understand what is a case management, what happens in a case management, so that you are able to, to imagine what kind of direction that can happen. So I'm asking what is the purpose of case management, or rather what usually happens, so that we can advise Mary based on the facts. Yes, Pius Oyo.
Yes, thank you. So in a case management conference, of course, Anyona has told us it is in Order 11. There is always a case management checklist that is normally completed by the plaintiff. So that checklist normally just have the name of the advocate or the firm that is representing each party. that is both the defendant and the plaintiff, their addresses, and if a party chooses not to be represented by an advocate, then the address of that party. And then there is always a list of pleadings that have been filed, of course, with the dates with which the pleadings were filed.
Okay.
Yeah, so looking at the facts of the case, of course, the court may give direction that the witnesses who cannot come to the court for hearing may swear an affidavit, and the parties may rely on the sworn affidavits, and the court may give directions as to how the proceedings are going to take place. Of course, in that case management conference, there is also a window where pleadings can be amended. And when they are amended, there is how they are supposed to, be served on the other parties. So I think maybe with your guidance, you could also add a few points.
Okay. For purposes of time, let me just proceed and say and explain. Case management, as you've seen, it's at order 11, and it usually happens after the pleadings are closed. So after parties have filed, the plaintiff has filed the plaint, the defendant has filed their defense, maybe they have filed their witness statements. So the purposes of case management, the main one, there are so many reasons it's listed in order 11, but the main one is for an expeditious disposal of the suit, and even to give parties, they can even decide to use ADR method. But in this case, we have been given several facts which are very important. You see, also in a case management, it's a time where you are going to say, I'm objecting to this document, I'm not objecting to this document. It's a time to tell the other party, I'll be bringing this witness, I'll be relying on this. Remember, we are under the civil procedures that were amended in 2010. It dispensed the trial by ambush. Prior to 2010, parties could just go to court at the hearing and now unleash a document. So that used to be the procedure then. But now, after the civil procedures were amended, there was need for parties to exchange documents. That's where order 11 came through. So right now, you just can't come to the hearing and start relying on a document. I have to have seen that document and told you during, say, maybe the case management that I'll be objecting to this, or I'll be requiring the maker to be called. The essence is so that if during case management I told you, I will be objecting to that because I need the maker. During hearing, you will come with the maker. We don't have to come to hearing and then start saying, I don't want this document to be produced. Then we have to, wait again. So in this case, I think after now you have already shown the examiner that you understand what a case conference is all about. Then you proceed to look at the facts of this case. The facts of this case is about witnesses. So remember, as you talked about, let me go to order 11 real quick so that I can read those facts just faster, then we can connect to this question. Let me go. Yeah, just a moment. Okay, I'm there. So order 11. Order 11. So it says the purpose of a case management conference shall be to 1, promote the expeditious disposal of cases, afford the parties an opportunity to use alternative dispute resolution mechanisms to determine the case, For the parties an opportunity to settle the case, determine any other matter relating to the management, hearing, or disposal of the case, and then deal with pretrial applications if there's any, identify the issues for determination. So in this case, let me go. We are being told about Jaden, who is a witness, and the witness is far. So this is one of the things that has to be settled. This is one direction that the court will have to give about Jaden, his evidence. And the client has already stated that he doesn't want the child to be going to court to give evidence. So you have to think, what direction can the court give? That's one aspect. Higher, there is about the person who signed the birth certificate. There is George. George is also a witness, and he's saying he won't be available. So I think, was it Oyoyo touched on that? So that's another direction that the court has to issue. So direction about witnesses and how they are going to, to testify has to be done. There is about here you're already told that the advocate has no problem in dispensing the presence of George. That's whereby about the affidavit comes in. And then there is the documents. So the court will have to give a direction on which documents that the parties have agreed on and which are not objected. And then there is a notice of inspection. This is the pretrial application. So this application has to be determined by the court first. So those are the things that happen in a case management. So that's the line that you'll be using when you are answering that question. I hope we are clear on that. Okay. So part B, distinguish between a case conference and a trial conference. Anyone who has a distinction? Difference between a case conference and a trial conference? Anyone? Jura Justice, yes.
Guided by your explanation and of course order 11, I want to state that case conference occurs when you're dealing with at the first time where parties comes to court and maybe giving direction on how you will deal with majorly the interlocutory applications that is before the court, and whether there are orders that are supposed to be given pending determination of the suit. Then trial conference now occurs where now you want to dispense with the main suit and the hearing is about to begin, in which case parties have to comply by filling in the questionnaire that sets out whether pleadings have been exchanged, where there is need to amend, and the court has to grant leave to do such amendments, and issues around how to admit evidence, and any other issue that is likely to arise during the trial. That is how I understand it.
Sorry, if you may kindly repeat.
Okay, so I started by saying that case conference, my understanding is that it is more of the first time the court is sitting to listen to both parties, that is the plaintiff and defendant. And during that time, normally issues around interlocutory applications are being canvassed, orders made where necessary, either by consent or out of court's own motion, and any other decision that is likely or that has a bearing on the interlocutory application that is before court. Considering that an interlocutory application has to be dealt with before the court embarks on the substantive suit. Now, the pre-trial conference now takes place when now the parties, once the case now gets into full hearing of the main suit, and issues canvassed there includes but not limited to: one, how evidence shall be admitted, time allocation, amendment of pleading through leave of the court being granted, among other issues. That is what I said. I hope I repeated.
Yep. All right. Anyone else before I? Yes, David.
Yeah, thank you. Given this is a marks question, but you never despise marks, I would have gone for the duration that case conference is usually held 30 days after the close of pleadings. Pretrial conference is 30 days to the commencement of the case. I think other than what Jura said, which I would have taken on some of what he has said, in addition to what I've just stated. That would have been my distinctive feature.
Yeah, thank you. So yeah, case conference is technically what I was talking about. It happens after you've done the case management. That's case conference. Trial conference is now you have already dealt with the issues of the case management. Now you're going to trial. So you are determining maybe time allocation, maybe the document that you needed to be admitted, maybe the time, just about preparing for trial, the actual trial, the actual hearing of the matter. So maybe you can distinguish it in that aspect, and and also on that timeline distinction. But yes, there's Alice. Alice, your hand is up.
Yes, I just wanted to comment that our lecturer said post 2020 amendments, we do not have a trial conference anymore. We just have a case conference.
Yes, that is very true. I think this question was asked because it was a 2019 paper. But right now we only have the case management or the 11. The trial conference used to be, I think, on the 11 rule 6, but it's no longer there. We check the civil procedure rules. All right. So I think we can move on. The next question. That is question 5. Let's try to do it as quickly so that we can do 5 and 6, and then we can call it a night. So question 5 goes like, I think the person sharing the screen has a bit. Daniel, your hand is up. No, it's amazing. Okay. Let me read question 5 as Alice tries to share the screen. Yes, there's a hand that is up, which is Elizabeth.
I wanted to help you reading, but it's okay.
Oh yeah, go ahead, please.
Miriam, Sami is the legal representative of John Joseph Sami, her husband, who was second defendant in Kajiado ELC number 89 of 27. Following his death on 23rd August 27, Miriam filed an application seeking to be substituted as a party in place of her late husband on 10th February 2009. The application was heard and allowed on 14th May 2009. The suit proceeded for hearing, and a judgment decreeing the cancellation of her late husband's title was delivered on 6th March 2015 in favor of the plaintiff, William Labana. On 8th March 2015, Miriam filed an application seeking of orders, among them leave to substitute her advocate, abridgment of time to enable her file a notice of appeal out of time, review of the judgment, directions regarding the mode of service of the application, and an order for maintenance of the status quo pending the hearing of the application and the intended appeal. The grounds upon which she made the application are that the suit had abated by the time she was joined as a party. The pleadings were not thereafter amended to reflect those changes. She was not given a chance to be heard, and that the delay in filing the notice of appeal was occasioned by failure by her advocate to inform her that judgment had been delivered and only learnt about it from the third defendant. Further, that the delay was occasioned by the hardship she faced in retrieving the file from her advocate to enable her instruct another advocate. Upon being served with the application, William has instructed you to represent him and oppose the application. Write a legal opinion and legal issues raised by the above facts and the grounds upon which William can successfully oppose the application.
Thank you. So before you go to the facts of this case, let me just ask, what are the ways to oppose an application? How do you oppose an application, rather? There is, okay, Donna.
You oppose an application through grounds of opposition, maybe a preliminary objection.
Okay, so Donna said grounds of opposition, preliminary objection. Another way? Yes, Elizabeth.
Replying affidavit.
Yes, replying affidavit. That's also another way. I believe those are the major ways. So in this case, which would have been the appropriate, or how would you oppose the application and why? After we have talked about grounds of opposition, preliminary objection, replying affidavit, how would you oppose this application and why? Yes, Evans.
So personally, I would use a replying affidavit because, as we've been told, the application raises a myriad of issues. So it's a mixture of issues of law and issues of fact, which I think would substantively be responded to by way of a replying affidavit.
Nice, thanks. Anyone with a different opinion or wants to add a point? Okay, so maybe I can say, yeah, you see, a preliminary objection, you can only object on matters law. Similarly, I think also grounds of opposition is usually it's similar to a preliminary objection. It's just that it's a grounds of opposition. It has to be matters law, but when it's matters fact, an affidavit would be better. So you would file and replying affidavit and swear why and swear opposing the application. So this question, did it say draft? It was like the question said write a legal opinion. Yeah, so it's a legal opinion. I remember the structure, what we talked about. So the issues raised. So I think I don't know what is the issues here. But anyways, I don't know, maybe your minds are shut down. Yes, Samuel. Yes, Samuel.
Okay, yes. I think that one of the issues is the fact that she has made in her application, she's seeking both an appeal and a review, which cannot happen.
Yeah, that's matters law, by the way. Nice. That's one of the issues. Thank you for pointing that out. Any other issue? And I also think when you're writing a legal opinion, you can even advise, maybe say, William, when it comes to the aspect of filing or the application seeking about appeal and review, and that can't happen. That's a matter of law, and William can oppose the application on that ground through grounds of opposition on that issue. Yes, there was another hand. David?
Yeah, so among the grounds she's giving as reasons for appealing out of time are that she was not given the file by the advocate. I do not think that she needed that file. All she needed to do was just launch a notice of appeal, or maybe probably she also needed to make an application in court to be enjoined in the case. So I do not think it is sufficient to say that the advocate was keeping the file, and that is why she is seeking to appeal out of time. It is not sufficient to me.
Yeah, I think you are relying on the case that says a case belongs to a litigant and not the advocate. So I think when you want to oppose in that aspect, that is a factual aspect, and a replying affidavit would best handle that. Any other? Yes, Donna.
Okay, I don't know how to frame this, but the fact that she said that the suit had abated by the time she was joined, I think in suits abate in criminal criminal cases are the ones that abate when the defendant or accused has died, but in civil cases they're always substituted. I think I'm not quite sure.
In civil, they abate if the defendant is not substituted within 1 year. So after 1 year, if 1 year ends and there is no substitution, then the suit abates. So it has to be revived again before substitution is done. That's what happens in civil cases. but she was substituted, I think. She had filed an application seeking to be substituted on 10th February 2009, and the application was allowed. So I think,
Yes,
for me,
yes,
I
she
would see
did.
as she's lying. She's saying I think that's also an aspect that you can oppose and say that the applicant is deceitful. And then, that is an aspect. If you're doing a replying affidavit, that one and replying affidavit will oppose it, because you can swear that the applicant is lying and show, and even annex that maybe the order that was given by court allowing her application. You can even annex that application of hers and show that she actually made this application was allowed. So that's something that you can reply to in a replying affidavit. So yeah, thank you, Donna, for that aspect, but that's a lie. She lied. Yes, David.
I was just concurring with you and maybe pointing out that the courts do not act in vain. She cannot disregard the orders of the court and then come later claiming that the seeking protection of the same court in that the suit and abated because she was not there when the judgment went against her as an administrator or maybe as a defendant representing the interest of the net. Yet when she was given the order, she disappeared from the court. So therefore, the courts must not act in vain, and she cannot now have a cake and eat it, come claiming the suit unabated and she was a party and she disappeared from the court.
Yes. Yes. So those are aspects that you can always oppose in a replying affidavit. Yes, Jura.
What if someone takes the route of preliminary objection, considering that she's seeking to do a review and at the same time doing an appeal, so that the matter can die once the preliminary objection is confirmed?
Yeah, that is mainly, I don't know about you guys, but for me, a preliminary objection is similar to a grounds of opposition, and when it appeal will always be good when it's a suit. I think when it comes to application, it's a grounds of opposition. Grounds of opposition.
But in ground of opposition, the presumption is that all facts are, you're not impugning facts.
Well, no. You can make grounds of opposition on matters law. The only part that you can't make, okay, you can still make factual, but I believe you can make a ground of opposition on a matters law. That's what I think, but I will seek clarity on the same. But for me, how I've been knowing is that we raise a PO on a pleading, and we raise grounds of opposition on an application. But I will seek clarification on the same, so that I don't mislead you guys, and then I'll state it in the group. But for me, it's you oppose an application through grounds of opposition or a replying affidavit. But I will seek clarification on the same. So yeah, that aspect that you're talking about, yes, it's something that you can oppose on matters law. All right, well, you guys, I'm getting a little bit tired, but I know maybe we might not have conclusively talked about this question, but we can quickly just brush through question 6. Question 6 is about amendment. It's asking you to amend. We can't read all those paragraphs. because it's a pleading, it's a statement of claim, and then you are told you were served with an amended memorandum of claim, and then you wishes to respond. So it's asking you to amend your statement of response. So technically, amendment is about, it's order 8, I believe, of the civil procedure rules. So, and I believe in this case, you are proceeding with the, I'm back, my network had. You are proceeding with the fact that the pleadings have not yet closed. When you look at order 8, is it order 8? Yeah. Order 8, rule 1 says that you can amend pleading without leave, and that is when the plead, any time before the pleadings are closed. And then if you are served with an amended plaint, you can amend your defense. So I think on the basis of order 8, rule 1, you can proceed to amend this response, and we know the way of amending, mode of amendment, rule 7. It is by striking out the deleted words with a red pen. So in this exam, if you didn't have a red pen and a ruler, tricky. And then the ones that you have added, you underline. So technically, you would have to redraft the whole thing. When you're amending, you have to write. You see how the question has written. You have to write exactly as it's written, but remember to add the, like, let me say, number 1, you are told claimant 7-day notice took effect on 4th May 2016. Let's come back over here. Paragraph 3 says, paragraph 3 of the claim is admitted only to the extent that the claimant was employed by the respondent as a manager with effect from 17th June 2015. And the first part you are being told is it took effect on 4th May 2016. Is it a 7-day notice? I don't think it's paragraph 3. I'm trying to find the 7-day notice where it is written in the question, and I can't see it. And I'm trying to read quickly.
Can I try?
Yes.
Okay, when I was going through this question, the issue was,
yes, go ahead.
I don't know. I want you, maybe you can clarify. Once you are employed, after how long are you put on probation? That was the trick in this question. So that you can calculate when you get employed, how many months are you put on probation?
It's usually 6 months.
Yes, so you are supposed to calculate so that you can know the day that he began the employment date.
That you can know?
When he got employed, so that you can amend that paragraph 3. Is it
Oh, we are okay. No, I'm not even talking about paragraph 3. I'm saying in after the response, they are telling you your client Building First Limited have looked at the pleadings and wishes to respond as follows. Number 1, claimant 7-day notice took effect on 4th May 20. So I'm wondering where that 7-day notice is in this this pleading so that I can change the date. Oh, I don't know. I'm not seeing it.
Look, if it's not provided for entirely, is it it's a new insertion?
Maybe. I think then you can say that he was given a 7 days notice. I think that's a new an addition. Maybe so. Anyways, guys, I am so sorry, but my mind is the one that is shutting down right now. But I believe amendment, maybe you guys can go attempt this question and try amend the statement of response, because this is a question I didn't even read, but it's just about amending. Maybe you can attempt, then you can always send me, you can always inbox me, and then I can look and tell you if you amended correctly or not. I think we have done well. We have managed to do the whole paper. Thank you so much for attending. Thank you for participating. I wish you all the very best. And this thing is a doable thing. Sometimes I look back and I can't even remember. There were times that I was here tensing and wondering what will happen, but I managed, and I do believe that you people can manage all these efforts that you are doing. Trust me, they will not be in vain. You will reap what you sow, and sowing, and even on a Saturday night, staying up to 11:35 p.m., just revising, it will definitely pay off. I'll put you in my prayers, and I am always available. You can always reach me out, maybe during the weekdays, if you need any further guidance. And I apologize in advance if I delay in responding. Please just bear with me. Sometimes work gets overwhelming, but I will definitely respond when you reach out. So thank you. It's been a wonderful night. I wish you a lovely night and a lovely Sunday tomorrow. All the best in your revision.
Thank you.
Thank you so much.
Thank you so much. Thank you.